Are we on air? All right, so that was a good video. So hello everyone, I'm Adrien de Hauteclocque. I'm a part-time professor at the Florence School of Regulation and a visiting senior fellow at the London School of Economics. I will be your host today together with Kaisa Huhta and Max Munchmeyer. So Kaisa, no need to introduce you, but I will still do. You're a part-time professor like me at the Florence School. You're also an associate professor in the University of Eastern Finland. And Max, you're a research associate with us at the Florence School. So that's the new issue of our case law update. We do it twice a year. Always very well attended, very interesting cases. So let's go. There will be questions in the chat, so don't hesitate to ask any question you may have during the presentation or in the end. We will stay under 1 hour and a half for sure, Kaisa. Maybe to give a bit of time to colleagues to connect. I see we are at something like 65 people, so and that's still going up. So maybe to give them a bit of time, I can comment a little bit on the cases that we have. We will discuss 9 cases. Well, actually 7 cases, but you have joined cases. We have a bit less than usual. No. However, in terms of their importance, I think that we're very lucky. Most of them are actually very important. We have a judgment from the Grand Chamber like that's the third one. So the Grand Chamber of the General Court, Austria against Commission. We have 2 cases, 2 stated cases, a bit less than usual, but the second one, Patch 2, have been discussed a lot lately and have wider implications. Then we have the taxonomy cases. One from Austria, and 2 under the Aarhus regulation. That we'll go quickly on these ones, and then we have the stream of the 3 ACER cases, and they're all very, very interesting. So I think we can start, Kasia, if you agree. You'll do the first 3, I think. So
yes, absolutely. Max, if you could, yeah, exactly. So like Adrien said, I have 2 state aid cases today. One that focuses on security of electricity supply, and the other one on nuclear energy, which, like Adrien said, is an exceptional case. And I'm going to spend a little bit too much, hopefully not too much, a little bit more time on that than the other cases. And then the third one is also about nuclear energy in a way, but also about the taxonomy regulation, and I think provides a really nice bridge to the case that Adrien is then going to discuss after me. But let's start with the first state aid case, which is PGI Spain. So in 2022, the Commission approved a state aid scheme aiming to reduce the wholesale electricity prices in the Iberian Peninsula by supporting the input costs of fossil fuel technologies. Several companies, including PGI Spain, sought for the annulment of the Commission's decision. And then last spring, in March, the General Court dismissed the company's action and upheld the Commission's decision to approve the state aid measure. Next slide, please. So if we look at the aid measure itself, it was taken in the context of the crises which both national and international energy markets have faced in recent decades. And by crises, Spain and Portugal referred to not just the new requirements of the decarbonization era, but also the energy crisis and the price implications of that. So what they did is they argued that because the recent developments had led to higher fossil fuel prices, there had been a huge influence on especially vulnerable customers, but also all economic activities more broadly. So the way they addressed this through the state aid scheme was to adopt a measure that entailed making payments to the operators of fossil fuel power plants located in the Iberian Peninsula, with the effort to reduce electricity prices on both the wholesale and, as a result, in the retail energy markets. The measure itself was financed by a contribution imposed by the Spanish market operator on buyers on the wholesale electricity market, and the amount of the contribution was determined by the proportion of the amount of electricity that they purchased. Next slide, please. So the companies, including PGI, challenged this measure, and they put forward 5 key claims. So first of all, they argued that the Commission had fundamentally misunderstood the nature of the measure. They also argued that the Commission had made outright mistakes in its assessment of the appropriateness and proportionality of the measure. Then the third argument was that the aid measure infringed key provisions of internal electricity market legislation that related to price caps. So Article 10 of the electricity regulation that concerns technical bidding limits, and then Article 5 of the electricity directive that states that prices should be market-based. And then fourth and fifth, the companies argued that the principles of non-discrimination and the protection of legitimate expectations were breached through this measure. Next slide, please. So in the end, PGI and the other companies lost the case. The court found no evidence of serious difficulties that would have required the Commission to launch a formal state aid investigation. It also did not find that the Commission's understanding of the measure was flawed, or that there was incompatibility between the measures and the electricity market legislation, especially Articles 10 of the regulation and 5 of the directive. And then finally, the court came to the conclusion that there was no evidence of discrimination or any breach of the principle of legitimate expectations. Next slide, please. So let's move forward to the second state aid case, which in my view is much more exciting and much more exceptional, maybe.
Kaisa.
Do you want to comment on the previous one?
Yeah, a little bit, because I think that's interesting. It's not that this case was particularly surprising, but we had cases concerning the energy crisis, both concerning national measures, but also EU-level measures. And if you look at this case, I think it's classic Tempus kind of case law. You remember Tempus was the case concerning the UK capacity mechanisms back, I think, in 2018. And I think the case follows that case law very clearly, even though I think the deepness of assessment was pretty good. So on that case, that's it. But I think that's interesting to give a little review of other pending appeals concerning the EU measures concerning the crisis, because I could find that we still have 5 direct actions at the level of the General Court concerning Regulation 2021, the emergency regulation on the intervention on high prices. So the appeals concerns the validity of the solidarity contribution and the revenue caps, and in particular, you have the Exxon case. So they are all pending. We also have, I checked, 5 preliminary references where the question of the interface between the emergency regulation and national tax provisions are raised. So I think we will be will keep discussing the crisis measure in next issues of that case law updates. I saw also that the Poland appeal against the regulation was removed from the court's docket on May 2025. It was an interesting case, but they removed the case. And I also saw that there were two cases we didn't mention concerning the crisis emergency measures. There were cases concerning Regulation 2022-2577, so the one on faster rollout of renewables following the crisis. And you had two cases introduced by NGOs under the Aarhus regulation. So they asked for an internal review of that regulation to the Council. And the main issue there was that whether the emergency regulation, in particular because it was adopted under Article 122 TFEU, was an administrative act under the Aarhus regulation. And then the General Court decided a few days ago, on 12 November 2025, that it was not a general act. It was not an administrative act. Of course, it was a legislative one. And even if it was kind of a bit peculiar, the procedure, because it was under Article 122 of the TFEU, that didn't change the fact that it was not an administrative act. And so that review under Aarhus was not possible. So all interesting developments. That's it.
Yeah, I definitely agree. And I think that overview really nicely highlights the complexity of how the energy crisis has been addressed with law and with legal measures and case law. So we have stuff going on so many different levels. We have directly applicable EU regulations. We have provisions in directives that allow for flexibility and national, the use of national discretion. Then we have national state aid schemes. We have energy. We have social policy instruments addressing vulnerable consumers in the energy sector. We have taxation measures, and no one really knows the full impact of the combination of all of these levels of intervention. So I think while these individual cases are just drops in the ocean, I think they demonstrate the complexity of what we're dealing with in the energy crisis setting. And with that in mind, I think that's a good segue to the next case, which, as I mentioned, is a rather exceptional state aid case and takes place in the context of nuclear energy. And like with many of these huge energy investments, the timeline of these disputes is really long. This case or this dispute or the origins of this dispute started 10 years ago, over 10 years ago. It was first notified to the Commission 10 years ago. And 2 years later, in 2017, the Commission approved a Hungarian state aid scheme for constructing two new nuclear reactors at the Paks 2 power plant in Hungary. Now, Austria challenged the decision before the General Court, which ended up upholding the Commission's original decision. But Austria did not finish there. It appealed the General Court's decision to the Court of Justice, which delivered its ruling roughly 2 months ago. And this is really interesting because and this is the reason why the case is so exceptional, is that the Court of Justice accepted Austria's appeal and ended up setting aside the General Court's judgment and the Commission's original decision. Next slide, please. Now, the aid measure itself, compared to the case as a whole, is pretty ordinary, I think. Nothing too complicated here compared to the average state aid measure. So the aid beneficiary was a company owned by the Hungarian state, which was responsible for owning and operating the two planned new reactors. So the project was based on a 2014 intergovernmental agreement between Hungary and Russia. And under this agreement, both countries were supposed to, and appointed state-controlled entities to carry out the technical and financial obligations involved with this arrangement. Now, the whole project was financed through a 10 billion euro Russian state loan to this Hungarian state-owned company. And this loan was complemented by 2.5 billion euro loan from Hungary's national budget. Next slide, please. So in its appeal, Austria raised 4 main arguments and really narrowed down its line of argumentation from the original 10 claims it had put forward before the General Court. So it had four claims. First, it argued that that not organizing a public procurement procedure for building the 2 new reactors should make the Commission's decision unlawful. Secondly, Austria claimed that the Commission's assessment of whether the aid was proportionate was flawed. Thirdly, it argued that the aid would distort competition and strengthen or at least create a dominant market position. And then fourth, Austria challenged the way the Commission had defined the key elements of the state aid itself. So 4 claims, but the court ended up only examining and ruling on the first plea concerning the absence of public procurement procedures. So basically the absence of public procurement ended up being at the very core of this case. And many of my public procurement colleagues and enthusiasts are super excited about this case because of this. So in its assessment of the first ground of appeal, the Court of Justice further broke its reasoning down to 3 parts. In the first part, in the first ground of the appeal, the Court of Justice criticizes the General Court for drawing an artificial distinction between the construction of the 2 new nuclear reactors on the one hand, and then the fact that they were given free of charge to the PAX-2 company on the other hand. So originally, Austria had argued that the measure contributing to the aid's objective should have been considered as a whole, rather than breaking it down into 2 different components. And then in the second part of the first ground of appeal, Austria had argued that the award of the contract for the construction of the 2 new reactors is directly linked to the aid measure, kind of complementing the first argument. And the Court of Justice examined these 2 elements together and found that the direct award of the contract was, and this is a quote, is inextricably linked to the object of the aid measure notified by Hungary to the Commission, which is aimed at developing those reactors with a view to their provision free of charge to the PAX-2 company. So basically, the court accepted Austria's claim that there was no meaningful distinction between the construction on the one hand and then the provision of giving this free of charge on the other. And then thirdly and finally, Austria criticized had criticized the General Court for accepting the Commission's reliance on findings from a separate 2015 infringement proceedings that dealt with Hungary's compliance with EU public procurement rules. And the court also ended up accepting this claim. Next slide, please. So there are a few interesting implications of the case that I see. First of all, I think that the case will further intensify the divide between those member states that actively support nuclear energy, such as Finland, and those that remain fundamentally opposed to nuclear energy. This is really not the first time Austria has tried to challenge other member states' nuclear projects. But it is the first time that Austria has been successful in doing so. And this ruling suggests that this kind of strategy of challenging other member states' nuclear mixes has been, or can at least be, successful and effective. And then there are some questions about what the judgment does for the role of public procurement law and also other secondary legal instruments in state aid control. I think the court's interpretation strengthens the Commission's obligation to assess the compliance of state aid measures with EU public procurement rules. But I'm also kind of curious to see if this will also lead to some kind of pressure to look at other secondary law more closely in state aid assessments that the Commission conducts. And I'm wondering, could, for instance, I'm looking forward to your thoughts on this, Adrien. I'm wondering whether, for instance, the extensive secondary legal framework we have for climate law, could that inform the evaluation of state aid measures in the future, and could that be used potentially to integrate environmental and climate considerations better into state aid control? We don't yet know, but this is something I'm really curious to see. And if you're interested in looking more into this case, you may want to check out the two publications on it. The one by Lee Hansha, who's also a professor at the Florence School of Regulation, has published a policy brief or a blog post on this. And my colleague and I have a peer-reviewed paper coming up about this case later, hopefully later this year or early next year. But Adrien, would you like to comment on this case?
Yeah, sure. I mean, that's of course a very difficult case, and actually, it was a kind of a blow for the General Court also. And actually, I had worked on that case back in the day, so I remember how tough that one was. Of course, there the question is to define what in fact that intensity of the link. Of course, the Commission is going to argue that it's going to be what's the word, because it always changes, inextricable, or
yeah, inextricably
indissoluble. So the closeness of the link is going to be there only on very exceptional cases, and only very rarely. So we'll have to see what that means. I mean, is that really so exceptional? Because when you look at the court's reasoning, it seems that it could be a bit broader than what we thought. So that will be the main thing. Then the question is also for the project itself, what the Commission is going to do with that now. And because I mean, it's a whole industrial project with a full supply chain involved, and then of course you need to ensure some legal certainty now for the project. You have also probably wider ramification. For example, I happen to know that on May 2015, the Commission introduced a new mechanism under the Aarhus Convention, so that eligible NGOs could review certain stated decisions, which I mean, it was a requirement. It was a request from NGOs for a long time, and the Commission always was of course very reluctant. So now we have that new mechanism. So it's only for certain stated decisions that are the one taken in phase 2. So after closing the formal investigation procedure under 182, but only for decision finding that the measure is compatible with the internal market, or that's a conditionality decision. So there are conditions to make it compatible. So I mean, a logical extension would be that if these eligible NGOs find that kind of link, they could raise it. So a link to a way to find if there is a link, and that through that link, that would create issues of EU environmental law across the board. then that could be raised by the eligible NGOs themselves under the Aarhus review process. So that's going to be very interesting to see. You even can wonder whether that would have ramifications for national courts, of course, that cannot rule on compatibility, but that have to look at other provisions of EU law with direct effects. So it's still really open what's going to happen after that judgment, but that one really for sure was the big one.
Yeah, I definitely agree. Lots to unpack in this case, definitely. But moving on, before I hand over the mic back to you, Adrien, moving on to the third and last case that I have for you today. Next slide, please. So as promised, it's both about the taxonomy regulation as well as nuclear energy. So the core of the dispute was the application for the annulment of Commission delegated regulation under the taxonomy regulation. And this delegated regulation supplements the taxonomy regulation, establishing the technical screening criteria to classify certain activities in the nuclear energy and fossil gas sectors as contributing substantially to climate change mitigation and climate change adaptation by kind of characterizing these under certain conditions as environmentally sustainable. Now, we've already established that Austria is quite fundamentally opposed to nuclear energy. So it again challenged this act with a whopping 16 pleas in law. Austria claimed that the delegated regulation infringed, among other things, several provisions of the taxonomy regulation, also the precautionary principle and the European climate law. And it argued, among other things, that the contested regulation would risk fragmenting the market and creating stranded assets. Next slide, please. So Austria's case against this this regulation really rests on the argument that including nuclear energy and fossil fuels as sustainable investments violates core EU environmental and legal principles. So there were essentially three elements to this, which I've listed here on this slide. So first of all, Austria claimed that nuclear energy inherently bears unacceptable environmental risks because of the possibility of nuclear accidents and the lack of permanent disposal solutions for nuclear waste. And in doing so, the legal kind of aspect of this in doing so is that it fails the do no significant harm test and breaches the precautionary principle. And then the second element to this is that classifying nuclear as sustainable is such an essential element of the law that it should have been decided by the Parliament and the Council and not by the Commission via this kind of technical piece of legislation. So in legal terms, there was an argument that the Commission had breached the limits of its powers that had been delegated to it under Article 290. Then the third element to this is that, or was that including nuclear in this category would create the risk of market fragmentation, as investors would inherently disagree on which activities were truly sustainable or the greenest, and that this kind of uncertainty or fragmentation in views would defeat the goal of having this common standard in the first place. And as a legal side of this element, this would then undermine the entire goal of the taxonomy regulation, which was to create clear, unified investment standards. And Austria ended up arguing that this would lead to market fragmentation because investors would disagree which activities were really sustainable or green in the sense of the taxonomy regulation. Next slide, please. So in this instance, Austria was not as successful in its arguments as it had been in the PAX 2 case, because the General Court rejected Austria's pleas and dismissed the case. The court confirmed that the Commission has a broad margin of discretion when carrying out complex scientific and economic assessments, and that this is very characteristic of its role under the delegated powers of Article 290 of the treaty, which, if you could recall, states that a legislative act can delegate to the Commission the power to adopt these kinds of acts of general application to supplement or amend certain non-essential elements of the legislative act. But any essential elements should be then regulated by the Parliament and the Council. The court also found that the Commission did not commit a manifest error of assessment when including nuclear energy and fossil gas as transitional activities. Sorry. And that both sectors were deemed sufficient to ensure compliance with the objectives of the taxonomy regulation. So they concluded that there was no breach of the do no significant harm principle or the precautionary principle. I think that's it for my cases. Unless, Adrien, you want to comment on this, I think it provides a nice segue to the next case, which also deals with the taxonomy regulation.
Yeah, no, I don't have much to say. I mean, that's a very complicated case. I mean, obviously, I mean, as you know, there are a number of delegated acts that were adopted based on the taxonomy, and these nuclear and natural gas activities were not introduced in the earlier delegated act for other activities because the member states could not agree with each other.
Right.
So in a way, it's a deal. And of course, it fits with difficulty in the frame of the taxonomy. And I mean, as far as I know, there's no appeal yet, but I would be surprised there's no appeal. Of course, it's very difficult to swallow, for example, that nuclear would be a transitional activity. I mean, for something that when you invest, it's for 50 years. So I mean, you've many angles of that case that are really interesting. I think one thing is also the scope of review. And I think the argument that the Commission has a broad margin of discretion is there repeatedly, and of course that a bit blocks a bit the kind of review I mean you can have. But well, I mean, very interesting case for sure. You have a question in the chat concerning PAX 2. So what I propose is that you think about it while I'm doing my cases, and then you can answer.
Okay, excellent.
Max, moving on. So we have the so very quickly on that one, because I will have to go more in depth into the ACER cases. So we had also appeals based on the Aarhus, appeals against decisions of the Commission not to review other delegated acts adopted under the taxonomy. In particular, the general one. So the one delegated act where originally there should have been nuclear and gas, but they couldn't find the time. There, the court was clear on the fact that first you need to target the decision, not to review, and not the underlying act, even though, of course, while assessing the pleas, the General Court will check, of course, the legality of that underlying act. Also, the General Court made clear that there's a continuum in terms of review between the administrative step of the review and the judicial step. So in theory, at least, you should not introduce new pleas that you had not introduced at the level of the administrative proceeding. So once again, as regards this setting up of the technical screening criteria, the Commission enjoys a wide margin of discretion. And this is really what comes out of the text, I think. Max, next, please. One thing, though, that was interesting was what are these conclusive scientific evidence and how do you take into account the precautionary principles? So if you're interested in that kind of issue, you might want to have a look at these cases. But in general, I mean, the court said that it doesn't require, I mean, to have conclusive scientific evidence that you have unanimity from the scientists, or that you have very strict quantitative thresholds, because data are uncertain. And that's, of course, very difficult to assess very often, which technologies and to what extent they contribute to climate adaptation or mitigation. So it's completely legitimate for the Commission to base its analysis on qualitative criteria, or even on thresholds that are that exist on existing EU legislation, like the Renewable Directive. So when you look at these three cases, I think on taxonomy litigation, you see that the appellants they face a very high bar, I think, and that's mainly because of this standard of review with the wide margin of appreciation. It's really hard, I think, to overcome. So now let's get to the ACER cases, please, Max. So we have three. The first one is the last sequel of the Aquin saga. So we've been discussing Aquin for a long time in this forum. So this one is about damages. So the Aquin, if you remember, was a project for an interconnector between France and the UK. And there were many appeals, many decisions, and so now at some point they decided to introduce a damages action. So I need to go back in time a bit so that you can understand really what's at stake in that damages action. Of course, for our colleagues that know very well the saga, they will know that, okay, on that slide you have only a few of the main elements, but of course a lot of other things happened. So in short, try to synthesize what happened since 2017. So back in the years 2017, 2018, so Aquin was listed as a PCI under the Commission delegated regulation at that time. And in parallel, it introduced an exemption request before the French and the UK regulatory authorities. They couldn't agree, so as per the usual mechanism, they referred that decision back to ACER, and the exemption request was rejected by ACER and then by the Board of Appeal. And we had that first appeal on case T33518. And that's the main issue in terms of finding whether there were a manifest error made by the ACER or the Board of Appeal that could be taken into account into the damages proceedings. In 2019, Aquin was delisted from the PCI list. So the Commission readopted a new delegated regulation without Aquin on that list. This gave rise to a rise of appeals, to a stream of appeals. The last one was, I think, adjudicated in 2023, so all rejected. The same year, ACER refused to re-examine the exemption request because one of the reasons why that exemption request was not granted was the fact that he was a PCI. So in 2020, Aquin introduced this time a new exemption request, so not a request to ACER to re-examine its former request, but a new exemption request before the national regulators. But by that time, Brexit had happened. So EU law was not relevant anymore for the interconnector itself, or the project of interconnector, and so the public consultation that was ongoing was discontinued, and so they didn't rule on the request. What's interesting is that same year, the General Court annulled the decision of the Board of Appeal to confirm the ACER decision not to grant the exemption. And that was on two grounds. The first ground was the question of the standard of review. So we discussed that case at length on repeated occasions, again, in that webinar. But in short, the question was how to articulate the standard of review of the Board of Appeal with the one of the General Court, because the Board of Appeal so that they could do only a minor, or let's say a limited review, like the General Court is doing. And the General Court said, no, you can't do that, because otherwise, why would you be there, in short? And so that was an interesting case, of course, because then we knew better how the Board of Appeal would have to exercise its power. But there was another ground. So in essence, the General Court judged that the Board of Appeal had kind of introduced a new condition under Article 17 of the cross-border regulation, which was you had not filed for a request for cross-border cost allocation as you were a PCI. And it was not, the argument was not, as you didn't introduce that request, then it means that you didn't need the financing or that the project is not risky. No, the argument was that there was a new condition under Article 17, and you cannot introduce a new condition under Article 17. So that was a bit, of course, adventurous, I think. In 2021, we were back to the ACER Board of Appeal, of course, as the earlier decision was annulled, and the appeal was deemed inadmissible due to Brexit, of course, because the Board of Appeal had nothing to rule on anymore. So in a way, Aquin was a bit cut both ways and couldn't do anything. And I think that was a logical step to introduce the damages action. So now we'll see what the General Court said. Basically, if you introduce a damages action, so you have the three Bergadem classical conditions. So you need to have a manifest error, you need to have damages, and you need to have a causal link between the manifest error and the damages. And so that spoils a bit the suspense, but the court ruled only on the first condition, which is the unlawfulness for the existence of, or the alleged existence of manifest errors from the Board of Appeal and also from ACER itself. So first it looked at this question of whether the Board of Appeal had made a manifest error by introducing a new condition under Article 17. And there you have a strange kind of reasoning about res judicata, because the General Court said that the Court of Justice didn't rule on that. And actually, it's not that it didn't rule on that. It didn't rule on substance. It just said, okay, we have looked at the issue of the standard of review. So then whatever, it would be ineffective anyway. So the court looked at that argument on appeal, but didn't rule on substance. And so the General Court said, so there's no res judicata on that special argument of the interpretation of Article 17, which I think is a bit surprising, because to me, once you go on appeal, then the reasoning of the General Court becomes final. And even though I didn't really see the link between the res judicata argument and the issue of manifest error. But whatever, I mean, this was a bit, it was kind of interesting. But the main part, I think, is that the General Court recognized that there had been a divergence, not between the General Court and the Court of Justice on that question, but between the General Court and the Advocate General. Which had sided on the side of Equind on that particular question. And so, of course, the fact that you have a divergence between the General Court and the AG opinion is in itself, and that's a bit ironic, that would be in itself a reason to conclude that that's a very complicated question. And if that's very complicated, then it cannot be a manifest error. So that's one bit. The other bit was to look at whether the Board of Appeal had made a manifest error by misunderstanding its own standard of review. And there, that was recognized by the Court of Justice on appeal. So when I say on appeal, it's on appeal from the judgment annulling the decision of the Board of Appeal. So of course there were difficulties in appreciating Article 18 and 19 of the first ACER regulation. This is not Article 8, it's not 8, so I think 18 of that time, it's 28 of today. So this is about the structure of the review of the Board of Appeal. I mean, who can apply and that kind of thing. And so, of course, there were difficulties in appreciating that. The General Court also considered that these transitional errors are excusable in a way. So next time you change job, don't remember your transitional errors are excusable. So that's kind of funny, but still, I think that was fair. I mean, to say that it was not a manifest error to have a misreading on the side of the Board of Appeal of its own review powers. Max, next one. Thank you. So the General Court looked at other possible violations. First, legal certainty, legitimate expectation, and equal treatment, because Acquient raised the fact that, yeah, others, like in particular Eleclink, who were in the same position than me, they got the exemption and I did not. So, okay, the court said, yeah, but that's case-by-case assessment. That's not going to work. Another argument that was interesting, raised by Acquient, said, yeah, but look, I had so much troubles with dealing in particular with RTE, so the French TSO, that didn't want to set up a full joint venture with me. So that made my investment very risky. So that should have been assessed under Article 17.1. Article 17.1 of the regulation is where you have the legal framework for the exemption decisions. So that was also interesting. The General Court said, no, the kind of risk attached to the investment that we have to assess is not linked to national law. No. Refusal to reopen the exemption procedure after the loss of PCI status. Of course, so then Acquient said, yeah, but you should have reopened after I got delisted, I think in 2019 or 2020. The General Court mentioned that there are no provision on reopening exemption proceedings. I think that's true, but however, I don't see why ACER could not, at least technically, have reopened, but that it should not, that's something else. And I think the court was very right to say that the PCI losing the PCI status was not a removal of an unlawful situation. That was for other reasons. So then it was not an obvious mistake not to reopen the exemption, the first exemption proceedings. And then, of course, you had the issue of the potential lack of speed or lack of vigilance from ACER and the Board of Appeal, because, of course, Brexit was advancing and they were waiting for decisions. And so the General Court looked really at the procedure and whether ACER and the Board of Appeal had been diligent in trying to come up with decisions, and actually they did. And when you see the time they took, I mean, I think it's fair. So the damages action was completely rejected. So interesting case, but the next one I think is even more interesting. Thank you, Max. So there, it's mainly about the architecture of technical and judicial review of ACER decision. So there, we are looking at the decision where ACER approved a pricing methodology for balancing energy. There was a technical price limit, I think, of close to 100,000 euros. The TSO came after with a proposal to introduce a new limit After public consultation, ACER decided to disregard the proposition of the TSO, but still to amend unilaterally the decision by introducing a temporary 15,000 euros cap, but only for certain platforms and only for a certain time by, I think, 1st of June 2022. So what that actually did is that some of the operators that had made some investments and that were active on the platforms, but yeah, well, there were a cap on the money they could get. It was not 100,000 anymore. It was like 15,000. So of course, they were directly impacted by this. So they appealed the decision before the Board of Appeal. And there, the Board of Appeal declared both appeals inadmissible. First, because there were not addressees of the decision, which is true, because the addressee of the decision were all TSOs of the region, of the core region, and said, okay, but that's a regulatory act. But even though that's a regulatory act, you're not individually concerned, so I can't rule on your case. So your appeal is inadmissible. So let me unpack this a little bit because that's not very obvious. So under Article 263, that's simple. If you're not a privileged applicant, like a member state, you have three ways to appeal. It's either you're the destiny of the decision, or you are individually and directly concerned, so that's classical Proman case law, or you are going after a regulatory act, so without implementing measures, and then you just have to show that you are directly concerned. However, Article 28 of the ACER regulation does not follow that. And there's nothing about the regulatory act. So what the Board of Appeal said is that there's a problem with Article 28. And I remember having read the decision, they were very honest about that. There is a problem with Article 28. So I can't read into this the fact that I can look at regulatory acts or at, let's say, appeals of operators that are only directly concerned. So I can't do anything, but there's a problem with Article 28. So I have to declare your appeal inadmissible. So of course, very interesting. So now let's see what the court said. Please, Max, I think we're still on time. So first, and that was not disputed between any of the parties apparently, but that's good that we know that, is that some of the ACER decisions are regulatory acts. So that means they are not legislative, but still they have a broader reach. And even though the addressees of the decision were the TSOs, a lot of the actors could maybe be directly concerned by that regulatory act. And it's true that in that case, there was no implementing measures. So what the General Court said is that they could have brought an appeal against that decision, but not before the Board of Appeal, but directly before the General Court, so without proving individual concern. So of course, that's very interesting, because in the end, it means that, for example, the addressee of the decisions will have to go before the Board of Appeal, whether others that would be only directly concerned will have to go before the General Court. I think that interpretation stands. Of course, you can discuss that, but Article 28 is what it is at this stage. And for sure, there's nothing about the regulatory act. And it's not because the treaty foresees that the legislators can define special conditions and procedures for agency appeals, then in exercising their powers, the different boards of appeal can decide themselves how to apply who is admissible and standing conditions. So here we are with Article 28. Next slide, please. Thank you. what was very interesting, I think even more interesting in that case, was that the court found implicitly a plea of illegality of Article 28. So, as you know, as an incidentally, when you are seeking annulment of a decision, you can, in certain conditions, ask the court to review the legality of the norm of superior law, so the one on which the contested act has been adopted. And of course, that was the main problem. In the end, the real problem was what can we say about Article 28? I mean, is that really compliant, in particular with the Charter, in particular Article 20 and Article 47, so 20 on equality and Article 47 on effective judicial protection. And there, the general court said that there's no gap in judicial protection, as RWE and Uniper could go directly before the general court, that only the other ones, so those either who are either addressee of the decision or individually concerned, directly and individually concerned, have to go before the board. Because that's Article 29. You have to exhaust the remedies before the board if you can use them. And that differentiated regime is objectively justified and does not infringe equality. And I think that's maybe the most difficult thing in that judgment, because in the end, the court said that you are in a different situation because in a way your level of closeness to the contested act is not the same that the addressee of the decisions. So you're further away from that act. So that's why you can't benefit from the special route foreseen by Article 28. So that's quite an argument to make. Then the general court looked at the direct action against ACER, the ACER decision, so the former one, and of course they were out of time. Of course, because they went before the Board of Appeal, so the 2 months time limit, had lapsed, of course, for a long time, so they were inadmissible, and which is a bit harsh, but not surprising, given the case law, is that it's not an excusable error. Because in the end, they got no assurance from anyone that the board was competent, and so they could not they could have gone before the general court directly. So, all right, okay. So implications. Next slide. We're 1 hour in. Of course, then that clarifies the division of labor between the Board of Appeal and the General Court. Of course, that's hardly satisfying, I think, because that you can have parallel appeals before the General Court and the Board of Appeal for the same decisions. For example, addresses and other actors. We have to keep in mind the old WD case law, which says that if you have a clear standing for an annulment action, then you're foreclosed of using afterwards the preliminary ruling procedure. So for all the companies now who are directly concerned by an ACER decision, they'd better appeal if they think that they want to, because it's not because you have a regulatory act and that there's no implementing measures that there will never be any decisions taken at national level. I mean, there will always be technical decisions that could end up before, national courts, and then, of course, you could want to go through the preliminary ruling procedures before the general court, before the Court of Justice. Sorry. So then that is not gonna. It's probably not going to happen this way. So yeah, companies should be careful now. So of course, it all raises the question of the reform of Article 28. We will see if one day we have that, but I think that would be welcome given that case. All right, so now let's move to the last case. So we still have plenty of time. Thank you, Max. So this one I think will be early, Kaisa. So that one is a very, very technical case in the sense that this time the General Court, I think in an enlarged formation, engaged with substance more than issues of standard of review or competence. So you have this Board of Appeal decision of 7 July 2023 that confirm a decision of 2019 on capacity calculation methodologies in the core regions. So why did that take 4 years? Is because in between you had the first decision of the board, then it was annulled, but it was appealed already by the ACER and the German government, and it was already annulled. And so that decision, it was, I think, on compatibility with Article 14 and 15 of the regulation. So now, in that case, we're looking about only one smaller aspect, but nonetheless very important, which is the issue of the internal critical network elements. So in my understanding, these critical network elements are transmission lines which are impacted by cross-border flows. And so they have to be included in the capacity calculation when they are impacted up over a certain threshold, which is a PTDF, so I think that's power transmission distribution factor of over 5%. So if they are above that threshold, I mean, they should be included within the cross-border within the capacity calculation. So there, I think when you introduce that kind of line within the calculation, the idea is the market coupling algorithm see that there is a potential bottleneck there and does not overload the network, which would create problems, not necessarily certainly a blackout, but then there will have to be national measures or measures taken further down the transmission network to address that issue. So in essence, it's a bit, where do you want this cost to appear? So in the regulation, it's fairly clear that these critical network elements are those that are over 5% of PTDF. But it seems that ACER came up with new conditions so that it could be included within the capacity calculation. And in particular, the TSOs had to do an impact assessment of raising the PTDF over 10%, and they had to do a big economic efficiency analysis to show that there were no reasonable alternative I mean, that was not the test. So that it was the most economically efficient to introduce that CNE within the calculation that compared to other measures. I mean, and it could be, I mean, whatever. I mean, bidding zone reformulation or that kind of things. So, of course, very, very technical, but actually very essential because in the end, it's still, in a way, a governance issue, because it's the question as to whether ACER could a bit take some liberty to impose the most efficient measures, or whether it had to stick with what was with what were the underlying conditions in the regulation. So, Max, next slide, please. So then the court engaged in a very, very complicated literal, contextual, and theoretical readings of the underlying regulations. And the outcome was that, yeah, ACER overstepped. That's, for me, I think where you can get that on substance. It found that there's no legal room to introduce an additional economic filter that kind of economic efficiency analysis may be relevant in the long term, but it doesn't mean that you can introduce a new economic filter that would allow you to exclude certain CNEs from the list. And that in the end, EU law, you cannot read EU law as it stands as forcing TSOs and member states to choose more efficient options. As long as the member states are on the trajectories, like the 70% trajectories that they have, or as long as minimum capacities are made available. So in the end, because ACER was saying, yeah, you need to interpret this according to some sort of general efficiency principles, and so that was a good argument. But the court said that no, you need a bit to stick to what is in regulation in the two regulations. So that's a very interesting case. It's also extremely technical compared to what we have usually, and I think with the last ones. So the first appeal, which was already very technical, you can see that the court, and I think even there was no external experts involved or appointed by the court on these cases, but still, I mean, when you see the outcome, it makes for an interesting read. All right, okay, I think I'm done now. Kaisa, do you want to add something, or? I can't hear you.
We still don't hear you, Kaisa. No, not yet. No, apologies.
You're not there anymore.
I don't know, Adria, if while Kaisa fixes her sound, maybe there's a question from Katja in the chat asking about litigation against emergency regulations, if you have any update on that.
But that's well, I did that a bit earlier, but I could certainly do it again. But I mean, I'm going to repeat myself. I mean, do you have a specific question, Katja? Or maybe you can drop me an email. But I mean, maybe I've been a bit quick on that. Kaisa?
Do you hear me now?
We do.
Yay! I figured I might leave the room and come back if that helps, and happily it has. I was about to comment to all of the cases that you presented. I think they were diverse in substance, but I think all of them demonstrated that really nicely, kind of the intricacies related to the delegation of powers and the division of competences between different institutions, how competences are divided between the states and the EU, like in the original Acquind case and the interpretation of Article 174. So who has the right to do what, and whether it's the powers of the Commission or what the ACER can do, what the Board of Appeals is allowed to do, what the roles are between them and the General Court, what should be left to the national regulator, and what should be kept with the legislator. I think whoever said that delegation of powers was a dry legal subject, I don't think it is. I had a few moments to check out the questions in the chat. I think there was a really nice issue a nice question about the nature of directives flagged in one of the questions. So one of the participants asked in relation to the Box 2 case that how should the assessment of the public procurement be conducted, given that the core rules of public procurement are included in a directive, which, as you know well, is not directly applicable, but has to be transposed into national legislation. And I think this is a really nice thing to flag, and it's something that that the court did not really take a stand on how the Commission should assess public procurement rules. But in the case itself, if you read the case itself, the court assessed the content and the requirements of the directive based on directly on the provisions of the public procurement directive, rather than how it had been transposed or whether it had been correctly transposed in Hungary. Then there was a question about what happens next, again, in relation to the PAX-2 nuclear power plant and the state aid measure in Hungary. So what happens next? So the Commission, I think, has to reassess the state aid in line with Article 266 of the Treaty of the Functioning of the European Union, which, if you don't recall, says that when an act has been declared void, the Commission or other EU institutions are required to take necessary steps to make sure that they comply with the judgment of the court. And I think then finally there was a question about the impact of the final nuclear and fossil gas taxonomy case on the eligibility of nuclear projects as a non-priority investments under the modernization fund set up by the ETS directive. Now, I'm not personally that familiar with the directive and the modernization fund and how they interact, but the case shouldn't impact the eligibility as it upholds the delegated regulation rather than changes it. So I think those were the questions addressed to me. Adrien, would you like to still comment on the mitigation against the emergency legislation?
No, well, maybe just on the first question regarding PAX, I think this is of course very interesting. I mean, it seems to me that the Commission has no competence to look at a purely national issue of public procurement, something that wouldn't have anything to do, if that's possible, to EU public procurement law. So in any way, it's going to assess what the national authorities did
in light of the directive.
Yeah, exactly. And so I don't think that's an issue. For example, that's there's a non-transposition or a wrong transposition of the directive. I think that wouldn't change anything.
Yeah, it would be very odd if the Commission assessed the compatibility of national legislation with EU law in its state aid decisions. That would be strange.
Of course. Then I mean, you can wonder a bit what is the interface between the infringement proceedings, because under an infringement proceedings, only the Court of Justice can say that a member state has breached EU law. So I don't know. I mean, there were some paragraphs in the decisions that made me a bit unclear on what the Commission can and cannot do. But well, maybe we need to look into this into more details. As regard the second question on the modernization fund, I don't think that has any bearing on that, in the sense that in the taxonomy case, I mean, it doesn't say that that nuclear should be priority. I mean, of course, the discussions on nuclear has changed a lot lately, but I mean, we are at the stage where we're becoming a bit neutral against nuclear, as regards nuclear. And so the court has said now repeatedly, like in the Hinkley Point case, or in that one, that, I mean, nuclear is fine, that you can have it under the taxonomy, or that stated control can accept that member state supports nuclear. But then it doesn't change anything as to the priority status of nuclear under, I don't know, whatever, the Net Zero Industry Act, or certain forms, or that kind of thing. So I don't think it has any bearing on that. As to the emergency question, so in the Polish case, well, actually there was no decision whatsoever. There was an order. So the court just removed the case, the Polish case, from its docket, just because the member states, Poland, asked the court to do so. This was my understanding of the order. So actually the order is half a page. So actually it was following the change of governments in Poland that a lot of the appeals, the new government proceeded that way. I mean, I remember actually we back in the days, 2 or 3 years ago, we had received a letter saying, okay, we'll be removing most of it, but there was one they didn't remove, was this one. I don't know why. And then this one was eventually removed. So now all these cases, of course, raised interesting questions. Of course, as to the relationship between Article 122 and 194 and that kind of thing. But so now on the emergency legislations, I think we need to follow first the cases of the general courts, and then through the preliminary ruling procedures, the one on whether it exhausts the field, or whether these emergency regulations, what is the interface with the national tax regimes in particular, because that was one of the main questions, because you introduced a contribution. But in contribution, what is a contribution in the end? Is that a fiscal measure, or is it not? If it is, then can the EU introduce under 122 a fiscal measure? All that kind of issues, I mean, will be very interesting, I think, to follow, and we'll discuss them.
Max? I think there was one final question addressed to you, Adrien, on the final case.
Two in the Q&A box.
So I'm trying to find it.
There should be a Q&A sort of, yes, if you. One was on relevance to state aid, and one about the bidding zone process, bidding zone review.
Yeah, so there was a question about, so as for the bidding zones, I'm not quite sure, but I think what matters is that it's said in the judgment that they are on the right trajectory. In any way, I think it's up to the Commission to do something under the infringement, its infringement powers. I think so. I don't think these rulings have any particular significance to that question, even though, well, of course, well, I think this is what is said in the judgment, as far as I could understand it, is that it's the competence. I don't think it's not that it's the competence. It's as long as you're on track with what you have to do, we're not going to ask you to change that. And so ACER could not kind of impose something else. And actually, ACER did not impose that at all in its decision, as far as I can remember. So could that be used in another procedure, for example, an infringement procedure? Well, I don't know. I mean, in the end, it's hard to imagine the Commission to go after Germany for that, but yeah, why not? So, yeah, difficult question. So I think there was a last one.
No, I think we've answered all of the questions. I can't find any additional ones.
Yeah, résolu, rejeté. I think we're good now. Yeah, Bram, yeah, I agree with you. I think that's up for the commission. And then if there is some reluctances, maybe an infringement procedure, but well, no need to reassess. Okay, this one re-answered. Now there is a last one from Vikram. Does the JC's reasoning? No, not really, because actually the idea was that there was not that kind of criteria under the regulation. So you could not base yourself on a constructive reading of the regulation to build kind of a legal test that gives you the opportunity to impose or to ask for additional measures to go towards something more efficient. But actually, you should read the case because this is interesting on the theological understanding of the underlying regulations. I think we're good. I think we've answered everything. So
I think so. I can't find any additional questions.
All right, so I think we can close now. So thank you to all the participants. Thank you very much, Kaisa. Thank you very much, Max, and to the FSR Secretariat. That was a good session. We will do it again. I don't know exactly when, but probably sometimes in first semester next year. No? All right. Thank you very much.
Thank you for listening. Bye-bye.
Bye-bye.